the order which was assailed in Supreme Court regarding the why this post was created. Whether it was to accommodate those persons who have lost their job. What my question is, the SLP is still pending?
May I answer your lordship in a different way?
SLP is still pending.
SLP might be pending, that is pertaining to illegality. A coordinate bench of your lordship's court has come to a conclusion that there is no illegality insofar as physical and work education is concerned.
My lord, item number 1, that is that supernumeric matter, my lord. I tell your lordship, on the last occasion, the even basic creation of supernumeric post was in question, and state argued.
Today, I want to hear that whether a date can be fixed, because
yes,
Mr. Sengupta,
I am appearing for some of the applicants. It is at times
already. I appreciate your anxiety. You are writing so many letters to everywhere. So some of the letters
have died,
unfortunately.
The verge of issuance of the joining letters.
Some of letters have come. I understand the difficulty. That is why this has been brought to the list under the heading to be mentioned. But এই ফাইলটা দেখি না, ওই একটা ফাইল ছিল, ওটা দাও। হ্যাঁ, ওটা দাও। না, এটা না।
দেখে কত?
All of same nature?
Yes, we are seeking addition, my lord, indicating that subject to what my senior
These
Mr. Sengupta
7 application,
we are indicating that we
7 application covers how many candidates?
That I do.
Who is your
we
junior?
have 189.
So total number of posts declared?
1600. My lord, 850 and 750 is the bifurcation.
1600 is before me because my direction was to notify about this litigation in the website of the commission. Possibly on that notification, your clients have responded. How many applications you are representing, sir?
I said 189, one application.
One application for addition only.
For addition, and
virtually the challenge is the capacity of the state to create such post. Now, wait, sir. The main writ petition is that whether state can create such supernumerary.
No, that is
not
the writ petition.
Yes,
there are 2 other issues also, ancillary issues in the writ petition.
What are the scope of the writ petition?
My lord, there are primarily two prayers of the writ petition. First, state has no jurisdiction to issue to create supernumerary posts. Second, my lord, if at all, in the alternative, if at all state has created supernumerary post, then the vacancy should be reckoned or appointment should be given in terms of ratio maintained in the rules. Those who have not only in the waiting list, but who have not in the waiting list, a fresh interview has to be conducted because vacancy has
have got 2 challenges. Number 1, state cannot create. And
this is the first. If we succeed, my lord, the second does not appear.
Waitlisted candidates should not be accommodated. These are the 2 broad challenges in the writ petition.
In my writ petition.
Now, why should I hear the parties the intent to add?
In my respectful submission, my lord, with deepest of respect, my lord, the applicants did not to be heard because, my lord, the state has created this notification for creation of supernumeric post. It is for the state to defend because they do not have any access.
So you are missing a point. Already creation has been matured into giving appointment letters.
My lord, creation?
Joining is awaited.
Therefore, they have a right, at least they may feel that Mr. Bosumollik may not be competent enough. Of course, he is not, like Mr. Sengupta, to defend their case. You cannot deny that. Therefore, what I will be hearing from them, whether adding or without adding, that how can you can justify your prayer in the writ petition.
Yes.
If they will be beneficial for me to hear Mr. Sengupta.
Yes, absolutely, my lord. Right? That is always a benefit for us.
But the problem, I'll be requesting, sir, to consider these aspects. If you see,
before your lordship,
what appointment recommendation.
May I point out?
My lord, appointment letter has not yet been issued. Only recommendation.
Now, your lordship, kindly bear in mind, very many substantial questions might have been raised.
The point is, your lordship will have to decide it today or tomorrow or day after. In the meantime, question is of in the meantime, what happens? Not certain persons have got recommendations, they will take it to the school, get the appointment and join. Now, if they do it, no one suffers any prejudice. If that is sustained, no one suffers prejudice.
The problem comes elsewhere. If you come to that, the last order which was assailed because of the creation of the supernumerary post was doubted by the learned single judge. You are aware of that. And justice learned. No.
Same notification. Same notification.
Now, this was doubted, the bona fide of the state to create such post. Some directions, investigations were made, assailed in Supreme Court. In Supreme Court, therefore, the order which was assailed in Supreme Court regarding the why this post was created, whether it was to accommodate those persons who have lost their job, the subject matter of
no, it is not.
No, listen. Now, from there, the Supreme Court has entertained that SLP and ultimately passed stay on that. You are all aware of that.
Well, after recording one thing, after recording that these matters are pending, and will not kindly visualize apart from a common notification.
Not giving any
What is that? I'm aware that
no, perhaps, will not kindly with folded hands. Not apart from a common notification by which these posts were created, there is no similarity. Insofar as work education and physical education, there is no illegality at all at any stage. At any stage, these 1,600 people are completely different. This is just not the common notification has been issued.
What is the exigency of creating
tried to clarify it.
Waitlisted candidates?
It is not the question of accommodate. No.
Yes.
It's not a question of accommodate.
Yes. Why? This is not the law of the land.
Gupta, wait. So this issue, Mr. Dr. Patho once tried to canvass. At least once he said that it has got no nexus with the
other issue, 5 to 6
illegally appointment or nothing. But directly, these 1,600 odd appointments were questioned by the court single judge.
No, we no.
Yes. This was, Mr. Bhattacharya.
50 to 61. 50 to 61 was questioned. And an affidavit came from the end of the SSC, which affidavit was withdrawn.
Not withdrawn.
Or not sought to be withdrawn.
In any event, creation of the investigation part that investigate into, question into CBI inquiry. My specific question to the erstwhile Advocate General was, please specify incidentally this question that state whether can create such post or not would not be raised in that. The Advocate General says, no, I cannot give that.
That point has been raised by the state.
Now, situation has developed from there more.
Yes.
More.
If now, the Supreme Court says, we shall confine ourselves only to 2 points. Number 1, whether this can be segregated. The list that can be segregated. Valid and invalid.
Yes.
And number 2, well, the inquiry that we have directed for taking cognizance of who are the persons responsible for creating this supernumerary post to accommodate
the illegally appointed persons.
No, we are not illegal. 100%.
So, has restricted its consideration to 2 aspects. I say specifically, no other aspect can be told.
No, I will hear it. Now, if you come.
Kindly seize the pleading in paragraph 14 of the writ petition. I was telling my learned senior milord.
Last occasion.
I'll be inviting Mr. Sengupta's attention to 2 of the observation of the bench constituted under the direction of the Honorable Supreme Court, which is now under consideration possibility. Now,
yes.
If you see paragraph
Your Lordship is clear, page,
paragraph 269.
Page 269.
of the Justice Boshak's judge.
My lord, yes.
Unless there is a deep and pervasive connection between the person perpetuating the fraud and the beneficiaries thereof with persons involved in the decision making process, such course of action is resolving to create a supernumerary post of to protect illegal appointment is inconceivable. Moreover, inconceivable. Moreover, each of the persons involved acted in violation of Article 14(16) of the Constitution of India. Whether such violations have resulted in criminal liability should be investigated into. Then come to
My lord.
Direction number Roman 8.
My lord.
CBI will undertake further investigation with regard to the persons involved in the state government approving creation of supernumerary posts to accommodate illegal appointments in necessary. Therefore, in my understanding, though there was a stay of the investigation, by the
Supreme Court, no stay of investigation was granted, no precipitative steps. Investigation regarding the investigation will continue. The 7th May order of the Supreme Court. Second page. 7th May order, it has been specifically said that state will not give any appointment from the supernumerary court.
এটা ধরুন নালে পড়ে যাচ্ছে
Your lordship has 7th May with your lordship.
না নামবে না পড়ে যাবে
Page 18.
Page
18, 35.
This is
Paragraph
7.
35.
Yes, 7th, paragraph 35.
Yes, ma'am.
No, I am not talking about. I'm not talking about this. I am talking about originally the direction by the coordinate bench to investigate.
That has also been stayed.
And that stay extension of
that stay, has been.
Subject to correction, coordinate bench directed that the creation of supernumerary posts should be investigated by CBI, and the prayer of the SSC to withdraw such application was rejected. From that order, an appeal was carried.
Paragraph 9. This is order dated 25th November 2022. 25th May 2022. Last pending further orders. The order of single judge dated 23rd November 22 and the order of the division bench dated 24th November.
That is what I am telling. From that single bench order, my lord, our division appeal was preferred before the division bench presided over by Justice Kopobroto Chakraborty. There, Justice Kopobroto Chakraborty upheld the order passed by the coordinate bench, single bench. From that order, 2 SLPs were filed, one by the state, one by the SSC. In that SLP, my lord, the order that your lordship is talking
about. Yes, now. The direction to the CBI to investigate at whose behest the interim application was filed before the learned single judge shall accordingly remain state.
My lord, that is the SLP filed by the state and subject to correction by the commission. Thereafter, my lord, that is pending before the Supreme Court also. That is also pending.
Therefore, what was the challenge?
Challenge is creation.
That, yes. No. Mr. Bhattacharya, the direction was, an affidavit was disclosed that for the purpose of accommodating such and such candidates, the supernumerary post has been created. Then it was taken. Who has directed it? At whose instance it is? All these things happened. It was traveled to division bench, from there to Supreme Court.
100%.
Ultimately, Supreme Court is saying
your lordship is correct.
Direction. Therefore, what my question is, the SLP is still pending?
Lord, may I answer your lordship in a different way?
SLP is still pending.
SLP might be pending, that is pertaining to illegality. A coordinate bench of your Lordship's court has come to a conclusion that there is no illegality insofar as physical and work education is concerned. Apart from that, I'm giving your Lordship the number. Apart from that, my lord, there is no inquiry at any stage. It is just, my lord, the common notification has been issued on 19th of May, which, my lord, through this challenge.
Want to say
that we have to segregate this group.
Want to say the direction of the coordinate bench to investigate by
is not pertaining to
regards to the appointments of this.
Yes.
Very well.
No, that is what we say.
But before that, above all, who is for the state here?
May I just throw your Lordship kindly attention to one paragraph of the Supreme Court? May kindly see paragraph 3.
Intermediary. Yes, they were told that the supernumerary is pending before the High Court. Very well, tell me paragraph.
It spoke of this challenge before the Supreme Court.
Yes.
In 2016, School Service Commission in West Bengal conducted selections for recruitment to 4 categories of posts. I do not belong to either of the
Yes, I understand what is you are saying, but the question is this way or that way, supernumerary. Now, let me understand from the state stand. State.
Your Lordship directed me on the last several occasions, directed the state to come up with an affidavit specifically stating that the power of the state to create supernumerary posts will not be a point of consideration before the Supreme Court. It was,
but they are not saying so.
While Advocate General, then also, my lord, Mr.
They are not saying so.
We cannot say so. And my lord, on the last day, it was the specific argument of Mr. Divedi, my lord, for the state that the state has power to create supernumerary posts, but since the matter is pending, we have not issued appointment. The court said,
Mr. Boshumulli, tell me, today are you in a position to give them pending all these matters with the Supreme Court? What is your instruction?
Only instruction which I have received, Lord, since this matter is still pending and slotted to be taken up on 7th. This is what I was told.
No, you just make inquiry from your authority. This is the position. In the Supreme Court, erstwhile Advocate General said, no, this may be an incidental issue before the Supreme Court. We cannot say very specifically that this will not be. The candidates tried their level best to get a clarification that the High Court can proceed with the writ petition challenging the validity or the legality of creation of those, but they failed to get it. I suppose they could not. The applicant, no, you are not parties there, sir. You know better than anyone that how you are an affected party, you can take out an application, only a clarification.
Out an application. That application must be decided, and they are moving here also.
We have not taken out any application.
Was rejected because this is not the subject matter.
No, the application was for mentioning was rejected for early hearing. But the
sir, do one thing. So why don't you bring all these things that you attempted to get the order of Supreme Court clarified that this writ petition can be heard or it has got no nexus with the pending matter. Then you put it in that way, but we fail to get it because registry has not allowed us to file an application. This is not the subject matter.
Well, I think, let
them say.
I think the presence of the learned Advocate General would let the Advocate General appear and apprise your Lordship, approve your Lordship's question. Because, I am telling your Lordship, all these persons are suffering so much. They are on the verge of starvation. One.
So just tell me, making all these press statements.
Yes. Before the registrar. And he said, well, since this does not come up in the subject matter, this 4
Mr. Boshumollik, bring an instruction whether you want.
Let it be taken up a
futile exercise. There will be futile. Even if I hold something, the state is not inclined to accommodate these candidates.
Well, the instruction that I have seen is, since the matter is posted on 7th, so we have no.
We can wait till 7th.
May I call the Advocate General?
Up to 7th even.
This is the instruction which I have received, Lord.
So what is the instruction to see up to 7th?
No, Lord, this matter is still pending before the Supreme Court, so Lord, and it has been seen on 7th.
I want a clear answer. If today the stay is vacated, if simply I decide that you have the power to create such post. Are you in a mood, or in a position to accommodate this?
I cannot say just now, Milord. I have to take instruction, written instruction, Milord. And AG
Take
is
this.
leading me in this matter. So, Milord,
Ask the AG to say. If he says no, we cannot consider, then why should I unnecessarily bother myself?
State decides we will not appoint. Court cannot direct you appoint.
And that what I am finding, the unfortunate these candidates are thinking the court is not taking the matter.
No, no. For a feeling of despair, say, we come every day. And Hindi cinema has developed tarik pe tarik, tarik pe tarik. So that is
This is a predicament of the court. You have to appreciate.
understand. The point is,
Where they ventilate their grievance, they have come rightly done. I am not saying to whom they blame. Of course, they have the only blame point is the court is not hearing the matter. But this is not the way. This is the position. I'm very much sympathetic with them. But if the state says that no, I do not want to give them appointment. Now we want to see up to what happened in the Supreme Court. Let us expect up to 7th. If everything goes, they will go automatically. They need not wait for the supernumerary.
Your Lordship, kindly fix a date on 8th or 9th. Any event, my lord, even if your Lordship.
But Mr. Sengupta, I want that you must apprise this court that whether under this situation, this muddy water, I can actually travel beyond it or not.
No, insofar as sorry.
yes,
Yes.
So,
Because my hesitation is that issue directly or incidentally is an issue before the Honorable Supreme Court.
submission is actually
Very well. Where is your leader? Because he apprised me in that day. Tell me when he is available.
No, we'll let the learned advocate general not only.
He will be informing.
No, today itself, only this information can be.
Not today, my lord. Only one day, my lord. Not today. Let us after 7th, my lord, any day, and let us state also.
Sir, there is no finding of illegality regarding these appointments are concerned. 1600.
First of all,
on 5th of May, my lord, there is a cabinet discussion. In the cabinet discussion, I have annexed, my lord, in the cabinet discussion, it is stated that there has been such and such illegalities. There are so and so waiting candidates in 9-10 work education. Concerning everything,
insofar as physically, if we can show that there is a statement regarding illegality, may not I go.
Any rejection at this stage, either of the application or any interim prayer, may result in a complicated situation for the waitlisted candidates, those who are expecting. So, first of all, I have to clear myself whether the state is at all interested to accommodate that. First of all, for that reason, I am placing it on 16th as a to be mentioned. Bring Mr. Advocate General. If he says, if today court lifts the stay order, we can accommodate, then I will proceed to decide with immediately.
Look at it from a different angle. If your lordship, there is no stay order, state is at liberty. Then if the state does not, we can press upon the state. Why are you sitting tight?
Let me know, because a case has been made out by the petitioner. Injunction is already there.
The appointment that is made shall be subject to further.
Place the matter in the list on 16 January under the.
May it be on the 10th.
To be mentioned. To get
ওদের তো কোনো ইস্যুই নেই আমাদের তো we are just on the verge
waiting list করা যায় না
আমি শিখিয়েছি
তোমার argument
next one. You take specific instruction.
Well, my lord has been kind enough to keep it on
16 January. 16 to be mentioned.
Please get subject to your lordship's program. A little precedence.
16, before 16, there are some other matters.
That is why I say subject to your lordship.
16 January, please.
Well, let the state file a report, indicating their stand.
Bring Mr. Advocate General.
And let the cans be allowed. Cans be allowed.